let's rock and roll. So first, everybody, hi, I'm Eric J. Troutman, the czar of the TCPA, partner here at Troutman Amin. I think y'all know who I am. But what you probably don't know, and this is a weird admission, I have actually never hosted a webinar before, it's just wild. I mean, I've probably done 100 webinars, but somebody else has always hosted them, and I've always been the panelist or the guest or the speaker or person or whatever. So I suppose I've absorbed, right, how these are supposed to be moderated. I've just never done one. So you guys are here on my maiden voyage. Thank you so much for being along. We're going to be talking about something critically important and something that I think I intuitively understand, but don't actually understand. And that's why I'm really excited to have a really great panel of folks that really do get the depth, complexity, and most importantly, the importance of the new 2025 CMS rule, which, as I understand it, essentially changes the contact rules for TPMOs pretty much completely and requires a very high level of express written consent for outreach. But before we start diving in, obviously, let's introduce our panelists. We'll start with you, John, just because you're right next to me. Like, who are you and what are you doing here?
I'm John Henson. I am attorney at Troutman Amin, specialize in compliance on TCPA, TSR, and lead gen regs. So that's why I'm here today.
And where were you before you were at Troutman Amin? Just remind everybody here.
Before that, I was general counsel at consumeraffairs.com. Prior to that, I was at Lending Tree for 7 years. So been in the game for a little bit.
Well, fantastic to have you here, John, and not just on this webinar, but at Troutman Amin. We love having you. And then next to him, at least on my screen, is the guy I know as the Bishop. Chris, why don't you introduce yourself?
Hey everyone, I'm Chris Deatherage. I am general counsel for Apollo Interactive. We are a performance marketing company. We operate in many verticals, including Medicare, leads, calls, clicks, that whole game. Yeah, I met Eric when I first jumped in the industry like most people did, and blew my mind because I was like, I had no idea this area of law, of just industry in general, was so legally complex. It's insane.
It is wonderful. And it's fascinating that a guy like me, fairly talented, fairly bright, fairly short attention span, could end up devoting an entire career essentially to one area of law, but it does move so incredibly quickly, and it's just so much fun, and the stakes are so high. There's just nowhere else I'd rather be. So great to have you, Chris. And then last but not least, not on camera, as I outed you earlier, Puja, because we've got like a makeup fiasco going on. My partner, Puja, go ahead and introduce yourself.
Yeah, thanks for that, Eric. Never a dull introduction with you. Hi, folks. My name is Troutman. My name is Puja Amin. I am a partner at Troutman Amin, better known as Queenie of TCPAworld.com. And like John Henson, I also work on compliance work here at Troutman Amin. Compliance work includes TCPA work, CMS guidance, TSR, FCC guidance, etc., as well as helping Eric with our litigation team.
For those of you who don't know what Puja looks like, this is her. So now you've got that visual image that you needed.
You just turn Zeno's camera on, and that'll work.
Okay, and Puja, before you were at Troutman Amin, you were also general counsel at a company, I think, that did some Medicare leads. Is that right?
Yes, I was general counsel at a lead gen company that did primarily Medicare as well. And then prior to that, I was at Loan Depot.
All right, folks. So let's jump in. We've got like a question and answer button down there. We've got a chat function. So if you've got some questions, let's ask them. I will do my best to field the questions. I have heard other people give disclaimers at the start of a webinar, so I suppose I will do the same thing. This is not legal advice. I mean, you know that. You're not listening to a webinar for legal advice. We're just going to talk about the law. Obviously, if you need specific application of the law to facts, something that you actually need legal advice for, we can help you, but so can other lawyers. But just don't rely on a webinar and be like, oh, I know everything. I can go ahead and course correct now based on that.
Eric,
all right.
I just want to interrupt you real quick. If only there was a conference of champions coming up in recent months where people could go and ask in-depth questions and get detailed responses. If only someone will come up with such an idea and implement it.
Yeah, that would be weird. That'd be great. Okay, thank you, Chris. So like this shows you how this webinar is going to go, guys. It's just off the rails. But no, go ahead. Seriously, ask questions as we walk through this. And I appreciate that plug, Chris. Yes, we do have a large conference coming up in July. Any of you that are interested in information regarding outreach, telecom, TCPA, obviously CMS, Medicare will be discussed, AI, really anyone in marketing, ad tech, telesales, this is the conference for you. We'll be breaking down all these issues. Lawconferenceofchampions.com, not affiliated with the Pac-12 or Pac-2, whatever it is, but we love those guys. Okay, so let's get going. I think we stalled long enough to let people in. CMS, someone please just, we'll start with you, Chris. Just give us the like literally the 100,000 foot level for anyone that's not really in the space. What is CMS? What's their role in legislating or regulating outbound calling around Medicare? Just give us like the highest level so that people understand what we're talking about.
CMS is essentially the FCC, FTC of Medicare. They regulate that space. That is their essentially their jurisdiction. If there are rules that are going to be implemented to effectuate the Medicare service or restrict the provision of Medicare services, that's their game. So if anything comes out touching Medicare, it's probably coming from CMS directly.
And who does CMS actually regulate? I mean, is it anyone that makes phone calls in relation to Medicare, or like who do they control?
So CMS directly regulates Medicare carriers, Medicare providers. So, think your Humanas of the world, right? But by proxy, through them, they regulate downstream entities who assist in that whole Medicare enrollment and provision process. So they define those as TPMOs, right? Third-party marketing organizations, which may be something that would also be covered by HIPAA, may not. I know John can probably go really in depth into that, but they, again, directly regulate the actual Medicare carriers, and then everyone else underneath them through proxy.
Yeah, and then John, just at a high level, go ahead, Puja.
Yeah, just to add to what Chris just said, just to be clear, TPMOs, the third-party marketing organizations, right, folks, that includes lead generators, folks that share and sell Medicare leads to insurance carriers, brokers. TPMOs can be organizations, they can be individual agents, all agents and brokers that are essentially compensated to conduct lead generation, marketing, sales, et cetera, any type of enrollment related activities on behalf of Medicare Advantage plans are going to be considered TPMOs under the CMS's umbrella.
Every time you talk, now I'm going to put this up so that people have a voice.
Perfect.
Exactly.
To associate with the voice. I'll be like, like this.
Just to give you guys an idea of how broad this is. I mean, this is the literal definition from the rules. A TPMO is an organization or individuals, including independent agents and brokers, who are compensated to perform lead generation, marketing, sales, and enrollment-related functions as a part of the chain of enrollment, right? So any part of that chain of enrollment, and you just perform a function related to that. I mean, it doesn't get much more broad than that.
And John just put that definition into the chat because he's always on top of it, and I love that. And so, but again, just as we start framing this out, the definition of TPMO is broad, but why does that matter? Help me to understand, right? Broad definition of TPMO. So what? You just told me that CMS only directly regulates the carriers.
Right. So it's important because it's essentially CMS is saying, hey, we can't really directly touch these third-party marketers you deal with, but we can make you touch them. So we're essentially going to say, hey, every rule we bind you to, carrier, we're also going to bind this super large group. And it's been effective for them, I think, but it's incredibly problematic in my opinion, because not everyone's the same, not everyone operates the same. Every relationship a carrier may have with a TPMO may be different. There may be different considerations as to why that relationship even exists. So it allows them to paint a broad brush of, hey, we're going to regulate everyone in the space by proxy. But the problem is that when they're using the definition of TPMO, they may be applying regs to you that don't make sense to be applied to you.
So,
And we're
as I
probably going to be
understand it,
talking about that.
yeah, so as I understand it, CMS basically only regulates directly the carriers, but the carriers are responsible under these rules to control the conduct of all TPMOs, which includes essentially anyone that's providing service to the carriers. So that essentially creates little deputies, the carriers serving as the deputies in their little universes to make sure that everything that takes place in the funnel leading up to the carrier, everything that any lead generator, telemarketer, anybody selling data or creating contacts that lead up to a carrier, right? They all have to comply with, let's say, Humana's take on CMS's guidelines. And so much like in the TCPA, where you've got different circuit courts of appeal that are kind of interpreting a rule in different ways, in the Medicare space, as I understand it, you've got carriers who are essentially interpreting the rules from the CMS in different ways and putting down into their funnels these specific restrictions that each one of the carriers think are necessary to comply with the CMS rules, and they don't always align. Is that right? Did I more or less get there?
Absolutely correct.
Well, you know, every dog has his day. All right, so John, because you haven't talked yet, so I'm gonna throw it over to you real quick. Recognizing that CMS is now regulating the carriers are going to do this trickle down effect of their interpretation of these rules. What's the cadence? Like, how often do we get rules from CMS? Is like a comprehensive set of rules, and what's happened recently that's brought us all together?
So we've been getting them fairly regularly on an annual basis, and they have, pivoted more or less. And the reason we're here today is because they just released one last month, and it actually was just published in the Federal Register today. So great timing on that. And this one is important for us as we've talked about TPMOs, because it talks about how TPMOs can share beneficiary personal data, right? And then of course, beneficiary would be anyone trying to get Medicare health insurance through a marketing company. So that's kind of how we ended up here today on this call on how they've changed the rules for this.
All right, Puja or Chris, can you guys just give me the bullet points? Like, what highest level, people tuning in, like, what do we need to know right now?
Yep. So as John said, right, the rule was released on April 4th. It was published today. Now, beginning on October 1st, 2024, this new CMS rule is going to require that TPMOs, all those entities we've already described, must obtain, wait for it, prior express written consent as defined by the FCC's new lead generation rule, which Eric, I would think, be a good time for you to discuss briefly what that requires. It's going to require that TPMOs obtain prior express written consent from a beneficiary prior to sharing that data with other TPMOs for the purposes, of course, for marketing or enrolling any beneficiaries into Medicare plans. Now, the new rule addressed the lengthy FCC rule requiring one-to-one consent, and the CMS has essentially adopted the FCC's recent ruling, but they did go a step further, which we'll discuss here in a bit.
No, tell me now. What's the step further?
That was your cue to talk about the FCC rules, the one-to-one consent.
But let's go the step further. Chris, what's the step further? Someone tell me what the step further is. I want to understand what the CMS rule is first.
Well, there's multiple steps further.
Okay.
One step further relative to the FCC is it's going to apply to manually dialed calls. It's not covered. There's no regulated technology distinction like in the TCPA.
That blows my mind. That blows my entire mind. And before we move off of that, does anyone know what the legal authority is for CMS to issue a rule that is more expansive even than the only federal law on outreach, which is the TCPA? Did they cite, this is where I ask you guys like the probing footnote questions, did they cite any authority for that, or they just did it?
They cited the FCC ruling, of course. Other than that, they did not cite.
I think they offhandedly just mentioned that they are allowed to regulate contact methods and particularly unsolicited contact, and that's what this was basically promulgated under. I didn't see any specific footnote argument of here's the exact section of the relevant code that we're pulling from.
All right, I know we've got a bunch of wonks on this webinar listening in, and this is your opportunity to prove how wonky you are. If you can give me the legal authority that CMS pointed to require express written consent for manual contact, right, which transcends and exceeds any TCPA restriction, I would love to see it. I believe there probably is some body of law out there. Somebody's going to jump on it. Right now, somebody's fingers are moving, and they're going to jump into the chat, and we're going to circle back to that. But I will take Puja's. Okay, so we give you a quick level set, right? So that's what you need to know at the highest level. We're going to break it down in a lot more detail. But CMS has said, in order for any TPMO to make any outreach whatsoever, regardless of the manner in which you're doing the outreach, you have to have express written consent, apparently that complies with the FCC's new one-to-one rule. Cue Troutman to talk about the FCC's new one-to-one rule. I don't want to. I want to moderate. John, you talk about the FCC's new one-to-one rule.
Sure. So in a rule that will go into effect in January, you have to have one-to-one consent to do telemarketing calls that is going to fall under TCPA, but it's also going to change the way a lot of lead generators and marketing companies do business and move away from back clicking here, you agree to having our marketing partners contact you. It's going to have to say you agree to having brand A, B, C, and D contact you. And you're going to have some express consent to have those brands contact you. Here, I think something that being overlooked by some people is that, hey, this is going to affect October 1st. So for all the people that are hanging on and saying, oh, we're going to wait till January to start our one-to-one implementation, like that's not going to work if you're doing these type of leads. It's got to be October 1st. It also knocks out the people who are saying, oh, we'll wait till after the election to see what happens. Well, you won't. So that's going to happen before the election. The other thing that's interesting is a lot of the things that we have seen, both at the firm and then in the industry, is companies saying we're going to rely on these check boxes. Maybe they'll be checked, maybe they'll be unchecked. CMS said, no, these aren't going to be. These are going to be unchecked boxes that the consumer has to go in and check the box for who they want to hear from. So that's the other wrinkle to this one-to-one consent that's been.
We're going to circle back to that. So summarizing one-to-one consent, at least in the FCC level, right? A consumer going onto a website will have to choose to hear specifically from each provider that they want to receive contact from, not from an intermediary, not from a lead gen, not from a marketing company, the actual end seller, the provider of the good or service the consumer is looking to consume. In the mortgage vertical, right, it would have to be Loan Depot, Mutual of Omaha, Wells Fargo, right? Not, Bob's Mortgage Shop or Bob's Mortgage Lead Gen or Bob's Advertising Shop that can provide you with finders, services to find a mortgage. So as we pivot over to try to apply that rule to Medicare, to me, Puja and Chris and John, I mean, this feels challenging because the role of a TPMO, I feel, is, and maybe I'm wrong, is to try to help the consumer to find the right plan, be it an Advantage plan or the right provider or carrier for them. Whereas it feels to me as if the consumer is being forced to make a choice at the front end, right at the beginning of their journey, without really the education or the value of a finder or assisting that consumer. They have to pick Humana or whoever it is they want to hear from right out of the gate. And again, to your point, John, it has to be unchecked, but they have to make that selection, I think, before they're aided by that website operator or by that broker or by that agent. This feels awkward to me in the context of Medicare, but maybe I'm missing it. Can you guys help me out?
Yeah, it is awkward. Remember how I said they went multiple steps farther? It gets even more convoluted than that. Because when you talk about the FCC's rules, like Eric just said, they use the definition of seller. You have to get consent for the seller, and that's the end provider of the product. CMS's new rules are convolutedly written. They jump all over the place, really. They conflate issues, but the main problem is that they focus on data transfer between TPMOs. So when they're talking about getting consent, CMS doesn't say the seller, they say the TPMO. right? And they say that because they're restricting it to TPMO, you cannot rely on being affiliates or anything like that. You have to be legally distinct entities, right? You have to get definite permission for the legally distinct entity to transfer data to contact you. So I have a question for you, Eric. How do you think that's going to play out when the end provider is, let's say, Humana, right? And let's say, you know, it winds, or Humana wouldn't be a good choice. Let's say the end provider is brokerage A, right? And brokerage A is full of independent agents. Who is the best entity to get consent in that situation? Under the FCC, you could probably get brokerage A's consent, but under CMS's rule, because it's TPMO specific, you would have to get agent A and brokerage A consent.
Chris, I am the moderator. Puja, answer Chris's question.
I completely agree with you, Chris. I know you and I both read the rule. I believe it was in, if you folks want to pull it up, it was section 6 under section 6A is where we're pulling this from regarding the data transfer and the choice of words that CMS has either intelligently or intentionally have used. But I agree with you, Chris. The way the new rules read is that you would have to essentially get consent on behalf of both. But how you do that with the new FCC ruling is, you know, really the question that I don't know that any of us have really figured out yet.
I love the way you frame that, intelligently or intentionally. It wasn't both. It was one or the other. All right, let's pause and answer a couple of questions. I think we framed it out at the highest level pretty well. Again, I like to have the webinars where we give people real clear takeaways. All right, so the real clear takeaway so far is that those of you in Medicare, right, for any lead starting, this is going to be active October 1. All right, so this is before, right? FCC's rule doesn't come into play until January 2025. This rule is live October 1 this year. Is that right, guys? Or is it October 1 next year?
This year. It's for the 2025 AEP.
October 1, 2024, right? This rule is active and live. Okay, so here's your first quick takeaway. Thou shalt not make outbound calls, right? October 1, 2024, unless you have one-to-one consent. Now, that one-to-one consent is a little bit different, as you just heard Chris explain, than the FCC rule. We're going to come back to that. And I really want to highlight the differences. I think it's very important for people to understand the differences. But that's your first core takeaway. Okay, October 1, right now, like literally, guys, 6 months from now, less than 6 months, you've got to have this one-to-one consent paradigm cracked, ready to go. All right, for this year,
regardless of what technology you're using, even if you're using your cell phone.
Even if you're any form of outreach via telephone, you've got to have this cracked. Okay, that's your first core take.
Doesn't matter if you scrubbed against the National DNC registry.
Correct.
Okay, hopefully this is all sinking in. All right, so let's answer a couple of questions here, and then we'll get to the other set of takeaways, which is what do we do? How do we solve this, right? That's where this webinar is going to go now. But first, let's answer some questions. Let's see if these make sense. First question, I'm just like reading these. With the new rules, does any permission to contact previously generated for a consumer before October 1st, 2024, is now invalidated for all consumers, including individuals in an agent's existing book of business, specifically for those that wouldn't meet the one-to-one consent requirements? So agent has a current book of business. Are they allowed to reach out to their own customers, basically, for this new cycle? Or are they not allowed because of the lack of the one-to-one consent?
That's complicated because, like I said, these rules were kind of convolutedly written. There's many instances. Okay, so just to give everyone the understanding why I'm saying this is convoluted, when they're talking about their new rule, it's focused heavily on the notion of transferring data between beneficiary data between TPMOs, but they have some offhanded just comments buried in there that talk about, well, we expect you to follow the FCC's rules. We expect you to follow these. So you shouldn't unsolicited contact an individual without prior express written consent, right? That can be interpreted one of two ways. They really only care about the data transfer and they're just saying, oh, by the way, follow the FCC's rules. Or they're saying, no, we are formally adopting the FCC's rules. Like, this is for all Medicare outreach. And it just depends on how you interpret that, right? So I would say if you're going to be safe and you really don't want to wind up on the bad side of the carriers or the bad side of CMS, the answer to that is all old leads that don't have one-to-one consent are dead.
That's interesting. Yeah, because I mean, the core of the question is there's no transfer, right? In theory, it's the agent just talking with their own existing customer without intention to do any form of transfer. But it does raise the interesting question of where did that lead come from to begin with, right? In other words, can them signing up, does that sanitize, right, the original source of the lead? And I guess you're right. Like, nothing in there says that it does. That's fascinating. That's a tough question. Look, way to ask good questions, guys. Go ahead, John.
To piggyback off what Chris is saying, not only that, but like, since it is about sharing information, and as we discussed previous, the definition for TPMO is huge, right? If it's in your book of business and you're going direct to a carrier, that's one thing. But if you're going to go to another broker, then you can't share that information because that's sharing the information with the TPMO and another TPMO.
Yep, great point. Great point, John. First, fantastic question. I don't know who asked that question. And that's you raised a really interesting point, John. What is the definition of sharing, right? Who are you sharing it with, right? Really, really understanding whether you're a TPMO sharing it with another TPMO is going to be really important in whether this new rule applies. My opinion, based off the reading, is that it's going to only apply when you are sharing, as opposed to your current existing leads that you are personally reaching out to. And there's one line that really sticks out to me where CMS says, in quotes, our final regulation seeks to place limits on the sharing of the personal data collected by a TPMO in a way that allows TPMOs to develop disclosure and consent processes that easily conform to all applicable rules that may apply, including the FCC's rule, of course. So, to me, it is only going to apply in the sharing context, as opposed to, if you have your own book of business and you're just calling those leads. I don't think the new rules are going to apply there.
How long was this rule? How many pages was it?
1,327 pages.
1,327 pages, and Puja just pointed to one single line within that tome to support a position off the top of her head. I just want to pause and just admire my panel, because we are so far ahead of every other law firm. Like, has any other law firm even reported on the 2025 CMS rules? I mean, maybe one or two. No one has done a webinar on it. No one has attempted to break it down. No one would dare to take live questions on this, but Troutman Amin and the bishop, right? Because that's how we roll. And the truth is, like, everyone's afraid. Everyone's so afraid to have their voice out there, because what if they're wrong? Look, we are here doing our level best, pulling out of a 1,300-page ruling single lines that support specific topics to try to give you the best, freshest, immediate take that we possibly can, right? Feel free to continue to read tcpaworld.com. We'll provide more breakdowns. We'll have more webinars, more content. But I just want you all just to recognize and appreciate the depth of understanding that and the courage that it takes for these folks to stand up here on a 1,300-page ruling and give you a one-liner that tries to support some esoteric position. This is incredible. What you guys are witnessing is incredible.
Brokerage? Is it an agent? Is it a brokerage that's independent? Is it an agent of an independent brokerage? Like, whose name needs to be on the form?
In practice, the entity that's going to be receiving the call, right? Or the entity that's going to be calling. And they're very clear about this, right? And this is kind of what I brought up earlier. If you have brokerage A, right, that's doing all the underwriting or whatever, and then they're comprised of independent agents. These agents are not on the payroll. Brokerage A cannot get they can get consent, but they're not the one who needs the consent. The one that needs the consent is the independent agent, because they're a legally distinct entity, right? And CMS is very clear about this. Being affiliated is not good enough. That might be good enough under the TCPA, right? Depending on your affiliation. But for CMS, they're like, no, not good enough. The legally distinct entity that's going to be talking to the beneficiary essentially is the one who needs to have been given consent.
So, Puja, what do people do? To this anonymous person's point, how can a live transfer lead exist where you have to have the independent agent's name and presumably, the call center is not going to have that, or the publisher might not have that. Like, how do we solve this? How do we bridge this gap?
Well, that's the difficulty, right? Especially for the folks who don't have the direct relationship with the carriers. Back to, when we were talking about the new FCC ruling, it's how do you start talking to your publishers? How do you start having these relationships with the people who are selling you leads so they understand what entity you're going to be listing on the consent disclosure? You're going to have to build relationships where you're able to dictate Humana be listed, Humana be picked, and only that call or that number is transferred then to the person who's going to be making the call on behalf of Humana.
All right, so let's flip this over. I brought this demonstrative device. Let's flip this over onto its head. Okay, we're gonna flip this over backwards. We've been talking about this from a bottom-up perspective, from a TPMO up perspective, from a lead gen up perspective. I want to talk about it from a carrier down perspective. The carriers want leads, right? And they want policies written. They want their TPMOs to have an existence. They want this to still be able to work. So if you're a carrier building out a funnel now, anew, seemingly, right? Doesn't the carrier have on its shoulders the burden, or at least the desire, to share as much information down to the next level? And then doesn't that next level have the burden and desire to share as much information about agents who's taking what calls down to the next level? And it feels like there's a cascade of need that starts at the top that should work to the benefit of the ultimate publisher, the ultimate folks, TPMOs down at the bottom, who might eventually get a little manna from above that will help them to do the things that they need. Are we wrong to try to solve this without their input? Should we just wait to see what the carriers want people to do? Like, help me to kind of unpackage this from a carrier down perspective.
I mean, I think you're right in some extent, but I think that carrier down perspective and practice is only going to be the next level, right? That direct carrier connection, I think they're going to care about that, right? But it's the secondary and tertiary levels that are going to have the problems, because I would assume, right, and Chris would know better than I, that those carrier agreements are going to pass the responsibility to the secondary and tertiary parties, right? And completely punt on it from their perspective.
Right. And that's particularly true because this restriction is not carrier to TPMO or TPMO to carrier. It's TPMO to TPMO. So it's carriers are going to have to deal with this headache in terms of knowing how the funnel works after that first step, right? So let's say, the carrier, has an agency that they work directly with. There's not much there's not much friction between agency and carrier. What the carrier has to worry about is agency to sub-agency, call center, email marketing affiliate, any number of other types of affiliate, click affiliate, search engine optimization affiliate. I mean, and I guess we haven't touched on this yet. I want to be clear here. Don't view the beneficiary data transfer in terms of existing data privacy laws that you've seen coming out through states. They use defined terms like PII, things like that. CMS just said beneficiary data. And beneficiary data is basically anything that a TPMO could collect from a beneficiary. So it's more than just two data points that could reasonably be connected back to a consumer. It's if the consumer gave the TPMO data, it's beneficiary data.
All right, so I love all this. I'm going to pause to go back to one of my original questions, which was what's the statutory authority that CMS is pointing to regulate calls made manually. And I'm going to give a prize to looks like a guy named Brian Carr. Well, I don't know you, Byron, but thanks for being on the webinar. Thanks for participating. He points out that Social Security Act section of 1851 H through J defines prohibited activity, including unsolicited contact, and that is the regulatory provision that allows the CMS to act here. So, Byron, thank you for that. Fantastic. It's in the comments for anybody that wants to see it, and we're going to get you a T-shirt. So email me, and we'll get you a free T-shirt, Byron, for getting that answer correct. All right, I'm going to do a few more questions here before we start wrapping up. It's amazing how quick this has gone. Sorry, we're already 42 minutes into this. So let me give you a few more questions. Basic question here. Is this CMS rule retroactive, meaning does it apply to lead generated prior to the rule going into place?
So the last line of the section of the rule says TPMOs must have prior express written consent to share a beneficiary's personal data on or after October 1st, 2024. So,
okay.
Yes.
It applies to, if you're going to be sharing that data October 1st or later, doesn't matter when you generated that data, it's subject to these new rules.
Yeah. So the answer is yes and no.
Yeah.
Right? Yes, it is retroactive to the extent that it doesn't matter when the lead was generated. No, it is not retroactive, meaning if you are engaging in that behavior today, you're okay. It becomes the rule on October 1st.
Correct.
Hopefully that makes sense to everybody. That's a very important point, right? And it's the same thing with the FCC rule, by the way, right? It doesn't matter when you generated the lead. You're not grandfathered in, right? Come in the FCC context, right? Come January 2025, you got to comply with the rule. It doesn't matter when the lead was generated. It's the same thing with this rule. Come October 1, you got to comply with the new beneficiary transfer rule. It doesn't matter when the lead was generated. All right, next question. And Puja, feel free to weigh in here. Just because you're hiding doesn't mean that you don't get to participate. Does the condition that the boxes cannot be pre-checked apply only from CMS when using the one-to-one rule, or is that a part of the one-to-one rule?
Just to be clear, are they asking if that boxes can't be pre-checked is also applicable to the FCC's one-to-one rules, or just CMS's application?
CMS application, as I read it.
Yeah. So my understanding, the Czar would know better than me. There's never been any hard rule or case law or anything that said pre-checking is per se bad when it comes to TCPA. CMS, again, went a step farther and they said, no, it is bad. I mean, I think I have the specific language right here I can share with you guys.
I have it up too. Chris, if you want me to read it.
Yeah, I have to find my documents.
Go for it, Puja, you win.
So it starts with Tpmo should use a consent method where the default selection is that the beneficiary chooses to not share their data. There should be an affirmative action by the beneficiary to acknowledge that sharing their data with another TPMO is permitted. By being able to consent to each listed TPMO through a clear disclaimer, beneficiaries can make informed decisions that best fit their personal preference. And that is where Chris is pulling, again, interpreting the language of what CMS was trying to get at there. They don't obviously use the exact pre-checked wording, but this section, clearly I think John, Chris, and I all agree that pre-checked boxes cannot be used in the CMS context.
And by the way, in the question in the TCPA context, I actually won the first case ever holding that a box can be pre-checked. That was the LaForce decision. Of course, the Czar brought you that law. But it looks pretty clear, though, from a CMS perspective, that you cannot have a pre-checked box. And again, there's a couple of very critical distinctions as we walk through this now between the CMS rule and the FCC rule, right? Again, to me, the biggest distinction is FCC rule requires the actual product provider, right, the Humanas of the world, to be on the form. CMS does not. It's the opposite. CMS requires the TPMO to which that beneficiary data is going to be transferred, has to be on the form. Unselected has to then be selected, right? So, I mean, you can imagine, who are these TPMOs? Sometimes it's like, Bob's Lead Shop. Like, you agree to have Bob's Lead Shop, whatever. I don't know. It's kind of interesting. Like the my mind started spinning, like in terms of how people have like named their businesses now to be attractive to consumers who are clicking those buttons. Anyway. Next question. This is an interesting one as well. If you are a TPMO that receives leads but does not sell them, is consent required? Or is consent required only if you intend to sell the lead?
What are you doing with the lead if you're not selling it?
Or you're receiving it?
You're
CMS doesn't that answer the, to me, that's enough information right there, though, right? If you're receiving the lead, then the consent was required, right? It's not that you, as the receiver, have to get consent. Go ahead. Puja?
I was agreeing with you. You as the receiver is not the one who has to get the consent, but you have to ensure the person who's providing the consent has, the proper consent.
Which is actually a good point to pause. Who gets in trouble for this, right? If I buy a lead, I'm TPMO, I'm Bob's lead gen guy. I buy a lead from Susan's lead gen. Susan did not get the right level of consent. Bob, got the lead. And then let's say I convert and then Humana buys it. I mean, does Susan get in trouble? Does Bob get in trouble? Does Humana get in trouble? Who gets in trouble? And what's the penalty here?
Everyone gets in trouble.
Everyone gets in trouble.
And it depends. And what the penalty is depends on where you are in the chain in your relationship, right? Humana is going to take the heat from CMS. Will that be fines? Will that be other type of sanctions or restrictions? I don't know, right? Well, where it's going to roll downhill is, the agency might have an indemnification agreement. If there's some type of monetary damages, Humana's going to turn around and go, agency, you need to compensate us for this, right? And then but I feel like the worst, at least in the, upstream TPMOs, marketer perspective, is quite frankly, a carrier is just going to send out an email to all their partner lists and say, hey, we had a complaint associated with marketing company A. Don't buy from them anymore. We don't want any more traffic from them. And it's almost like it can be like a death knell, similar to what you see in the TCPA space with carriers.
That's brutal. I mean, I was going to ask how important is indemnity provisions in these contracts then, but it doesn't sound like they're that valuable, because if Humana can just say off with their head, then that's it, right? Indemnity doesn't really matter at that point. Okay. Next question here, and then we're going to wrap up in about 5 minutes. This is good though. Really good discussion. Keep your questions coming. We'll get to them if we can. Can a lead generator call the consumer on the lead buyer's behalf? Meaning brokerage A was selected by consumer. Can TPMO A call for brokerage A and transfer them? And under the FCC rule, by the way, the answer to that is yes. But I don't know on CMS.
Under CMS's rule, the answer is apparently no.
Wow.
They're legally distinct entities, and the entity, you need permission from the consumer to pass it to that legally distinct entity. So for that to work, the consumer would have had to have clicked the box for brokerage and click the box for TPMO call center.
Wow. That is brutal. And so if TPMO call center
can't be pre-checked. They cannot be pre-checked.
If TPMO call center, though, like literally was ingested by the brokerage now owns TPMO call center, then that would be okay. But it would have to be a true employee-agency relationship.
It had to have been a complete acquisition, a complete absorption of the company to where they are now one distinct legal entity. They are not two distinct legal entities.
Do you expect that to happen? Do you expect that's going to be the consequence here?
Yeah, they're clear. I mean, you can be a wholly owned subsidiary. It doesn't matter. You're a distinct legal entity. You need your own for express written consent to have the data transferred to you.
John, you were going to say something there.
I was going to ask, Chris, do you think that's the end of call on behalf too, like third-party call centers?
Sorry?
What about third-party call centers?
Third-party call centers? Yeah, that third-party call center, because of the definition of TPMO and how broad it is, that third-party call center, and I guarantee you, is a TPMO. Because they're legally distinct, that you would need the permission for the brokerage to get the consumer's data from the TPMO, because the brokerage is also TPMO because of how broad it is. And then you need permission for the brokerage to send the beneficiary data to their third-party TPMO call center.
I agree. I mean, the example in the rules of two independent agents can share information, right? Yeah. You're going to take that to the logical conclusion. The third party call center would also be prohibited.
Yeah, if you're an independent agent under the same FMO, you cannot transfer data between each other. Right? Like it's that granular.
All right, guys, we're getting to the end here. There's a few more questions. We're going to skip them because I've got 2 questions that I want answered. First is the most basic question, right? Let's say you're talking to folks on this webinar. Obviously, we're not giving legal advice, but we do want to give some practical advice. Like, what practical advice can we give to people? How can they comply with this rule, right? In the TCPA space, you guys hear me all the time on podcast webinar. I want to give people actionable advice, actionable things they can take away, they can actually build around. What actionable advice can we give people to build around to comply with this rule? Chris, will start with you.
Oh boy. Well, the first thing is that you got to get your forms in order. You got to, if you're a lead generator that operates an online web form, you have to get your forms in order.
I just lost your audio. I'll give you back. Go ahead.
But if you're a lead generator that operates a web form, you have to get your forms in order. That should be task number 1. Because if your form is not in order and capable of getting one-to-one consent, you're not going to generate any leads. When you're also probably going to have the issue of, if you deal with aggregators, right? Like, let's say you sell to aggregators, you sell to brokerages, you're going to have to try and find probably some direct connections. It's highly unlikely, I think, that you're going to be able to get a consumer to click on at the same time to send their info to the aggregator and the end broker. Not impossible, but those of you who operate web forms and see how these A/B testing and stuff works, it's going to be hard.
All right. Thank you, Chris. Love it. John, over to you. What practical advice can we give people to start building around to comply with this very complex rule?
Yeah, I echo what Chris says about your forms. Not only that, the disclosure, we really didn't even talk about this much. The rules harped on clear and conspicuous, clear and conspicuous, clear and conspicuous. And I know that is a phrase that we're familiar with in the lead generation space, but still we see it every day, forms that don't have clear and conspicuous disclosures. And so we can add another 3-letter acronym into this. The CMS rules stated we're looking at the FTC definition of clear and conspicuous, which is difficult to miss. So not only you're going to have your one-to-one consent there, it's got to be difficult to miss and easily understandable. So I think that is the key.
Does the Troutman Amin 15 help at all here, John? Is that going to be a guide for folks?
It does. It does help. It is clear and conspicuous if it's done with the right font and color size. It is also easily understandable. So I think that would definitely help.
All right, I'm going to drop that in the link while Puja answers the same question. What actionable guidance, Puja, can we give people to build around in compliance with this new rule?
Well, I back to what we were talking about just right before Eric was asking our final thoughts of really understanding whether you are a distinct TPMO from the entity you're sharing or trying to share the personal data with. I think, that's step 1, right? Do you have to comply under the CMS rules? And why do you have to comply, right? Same advice that I gave for TCPA. Does the TCP apply to me? Well, it depends, right, on what technology you're using, whether you're doing it for marketing purposes. So I think step 1 is, do these new rules apply to me? And the first question you should be asking is, are you a TPMO that is sharing data with another TPMO? And keeping in mind, that the CMS does harp on, comments on, just because you're affiliated with an organization, that doesn't give you a right to share the data without the prior express written consent. Now, I think it's important to also keep in mind this one small little exception that CMS did provide, right? And seeing if that is something you can leverage when you're trying to operationalize and switch your marketing campaigns. And that is the live transfer rule, right? So if you can utilize and, work with other entities and have and get that consent on a live call, you can leverage this and get that call transferred to you, right? So talking to your agents, maybe doing some more scripting there to see how they can potentially get that consent on that live call, so you can utilize this one exception to the rule.
All right, so we're going to throw it around for final thoughts. Thank you for that, Puja. Before we go, I'm going to do my final thought, which is, if you folks love us, if you enjoyed this webinar, give us some love. We do this stuff for free, right? Give us some love on social media. Say great job. Encourage other people to check out our content. Subscribe to our YouTube channel, right? That deserves to win. And come to our conference, right? In July, the Law Conference of Champions. Visit lawconferenceofchampions.com. Give us some love. We give to you. Give us a little love back. That's all. Just a little love. You don't have to hire us. I'm not asking you to be our client or anything. That's desperate. But just give us some love. Be part of our little ecosystem, and we'll keep giving back to you. All right, those are my thoughts. Let's wrap this up. Let's do some final thoughts. John, actually, I'm going to start with you. What are your final thoughts overall? It can be whatever you want. Whatever takeaways you want people to leave this with. Something to put in their pocket and walk away with.
Yeah, I think that there are a couple things that immediately stand out are the applicability to this rule, like Puja said, is broad. There's a lot of TPMOs out there, including people who don't think they're TPMOs. Personal beneficiary data is what we've been talking about the entire time. That's a broad definition as well. And the last thing is October 1st will be here before you know. So make sure you're planning, testing, understanding who you're sharing your data with now.
Love it. John, fantastic. Always great to have you. Great thoughts today. Puja, going over to you. What are your final thoughts? Fill these people's pockets up as they walk out the door.
My final thoughts are, I think a lot of carriers, a lot of TPMOs are still processing this new rule. As Eric correctly pointed out, no other law firms are even blogging or talking about it. I've been hearing through the grapevine that a lot of carriers are also, freaking out, and they're still trying to digest these new rules. As more information becomes available from what Troutman Amin hears or Chris hears, we will try to release that information, as long as, of course, it's not privileged information, to keep you folks updated. But it is critical that if you are in the Medicare space, that you're keeping up with this new rule along with the new FCC rule. And you can check out tspayroll.com, and we will do our very best to make sure that we are keeping you updated as well.
Love it, Puja. Loved having you here, even though we couldn't see you. A lot of people asking, was it a bad hair day? No, it was a bad makeup day. Last but not least, the powerful bishop, Chris Deatherage. Always wonderful to have you from Apollo Interactive. What are your final thoughts?
My final thoughts are, this is going to be difficult, everyone. There's no getting around it. But as an industry, we got to adapt, at least in the short term. If you really hate these rules like I do, reach out to your local representative. The reality is that CMS also has bosses. So if you think that regulators as a whole are coming down on the industry too hard, reach out and let your local representatives know. I will say this though, because someone asked earlier about contacting an old book of business. I'll just leave you with this. At the very end of CMS's section covering this, they say, also, we explain that prior express written consent from the beneficiary to share the data and be contacted for marketing or enrollment purposes must be obtained through a clear and conspicuous disclosure. What's the takeaway from that? What is this rule really all about? Is it transfer beneficiary data, or is it also about marketing communication?
Oh, I love it. Why didn't I ask that question? Well, next time. A lot of you folks have already asked us for additional webinars. We're going to have more content. We're going to have more webinars, including on the compensation piece. We're going to talk about that. Why not? We'll dive into that. That's what you guys want, right? This was our first ever, by the way, Troutman Amin webinar event. We will have more. I promise you. Now that we figured out how to do it, and then I can do a couple of blogs and an email and get 150 of you to show up. Cool, man. I'll do some more of these. But seriously, go on LinkedIn right now and talk about how great we are. We love all of you. You people are fantastic. Thank you. Chat soon. Bye, everyone.